Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Heldt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
Hey, welcome back to the podcast. This week, my guest is Richard Miller, and Richard is a certified elder law attorney. Welcome, Richard.
Nice to see you, Gary. Thanks for having me.
Sure. So, give us some of your background. What is it that got you involved in law, and why do you like it so much?
Well, that's kind of a general question. What got me into law was my mother, and I apparently had no other skill set. So she said, "You're going to go to law school." I said, yes, that's where law started. That's the big picture. Small picture is I had this fantasy that I was going to be, this entertainment and sports lawyer, and I was going to be meeting all of these celebrities and athletes. And that's kind of, was the dream job at the beginning until reality set in.
Right.
And I realized that is not my personality at all. When I was in law school, I took a number of classes, and the one that resonated with me the most was actually trust and estates. And I thought that would be the most boring class ever. Who could possibly make trust and estates an interesting topic? And by way of background, I also had a very special relationship with my grandmother, and always was kind of well liked by the seniors. I got along better with the grandmas of my classmates than some of my classmates. I could have gotten them to go to the prom easier than their granddad. So I had that type of relationship, and I just felt that the trust and estates work was really very personal. You were dealing with people on the most personal, intimate levels and those aspects of their life. And it contains a lot of social work. So I often, talk about myself as sometimes being an overpaid social worker. But that's what got me into this field. And from there, it's kind of blossomed from the trust and estates to the elder law, which is then kind of navigated towards a lot of probate litigation. And people look at that and go, isn't that dull? Isn't that just so boring? And I say, this is like practicing and watching reality TV every day. There is not a day that goes by that is not some form of reality television.
Right. Can you explain to our listeners what elder law is?
Sure. So elder law is kind of an umbrella that incorporates a lot of different practice areas. Mm-hmm. One of the ones that is most associated with elder law is government benefit planning, and specifically as it relates to Medicaid. And Medicaid is a government benefit program that really is the only one that pays for long-term nursing care. And it's a program that's really needs-based, and individuals have to have relatively few assets in order to qualify. But one of the things people come to us for advice is how do we protect the assets we have worked our entire lives to generate and preserve, and how are we going to make sure it's not depleted in the final years of our life? And it's interesting because now I have a lot of years under my belt. This is in 33, 34, something in that range. And when I started, the focus wasn't so much on the cost of elder care. Yeah, that was still a big deal. But when I started, it was federal estate taxes that were the big deal, because the federal estate tax exemption in 1992 was $600,000, and nearly everybody that you came across was over that limit when you factored in their homes and their retirement accounts. So that was the major focus. Nowadays, with the federal estate tax threshold so high, and many states not having an estate tax or an inheritance tax, that's really not applicable to many of the same clients that I used to meet. But what is applicable is people living longer, more people needing long-term nursing care, and the cost of that being, upwards of $160,000, $70,000, $180,000 a year. And that's every year for as long as you need that care. And that's only one component of it. That's if you're in a nursing facility. And the way the system works, it essentially encourages or forces people into nursing homes because the benefit programs available for in-home care are very few and far between. So one of the things with elder law is how to protect people's wealth accumulation, not only for the children, because yeah, the children are important and people want to leave inheritances to their families. I get that. The first priority when we talk about asset protection is for the individual, him or herself, and for his or her spouse. Because if those assets are depleted, it also diminishes choices. And what money does is it provides options for people. If
Right.
people have assets, it provides them with more opportunities and more options. It allows them to bring in care. It allows to supplement the aides in a facility, maybe bring in personal assistance, whatever it is. It's not necessarily about expediting the qualification for benefits to make sure that children receive a larger inheritance. It's to make sure that people's lives, that they live with the most dignity, the most autonomy, and the most choices available so they can live out the rest of their lives as comfortably as possible.
Now, lots of times you hear that, hey, if you have, all of your money and houses and belongings and everything else in a trust, then at that point, you're able to get these benefits easier without losing your assets.
That's true, but it's always the nuances and getting into the weeds a little bit because there are different types of trusts. There are living trusts and revocable trusts that people often do to avoid probate. There are insurance trusts. There are testamentary. There's a whole lot of different trusts. There are opportunities through irrevocable trusts to protect assets, to expedite the qualification for government benefits. And that's all based on the one concept of a look-back period.
Mm-hmm.
Medicaid is a federal program. So some of these rules apply no matter what state you're in, but the Medicaid programs are administered on a state level. So there are nuances within each state as to how these programs are administered, but every state has a 5-year look-back rule. So if anybody transfers assets within 5 years of applying for Medicaid, those transfers are going to be discovered, they're going to be reported, and it's going to result in an ineligibility period to receive benefits. So one of the things people do as a basic plan is they take assets and they remove them from their name and they put them into an irrevocable trust. And as long as that irrevocable trust is structured properly, then it will begin the 5-year clock running for Medicaid purposes. People often try to avoid the trust, but like everything else, there are pros and cons. People could transfer assets outright to children, avoid the trust, but that has to be considered on a case-by-case basis because when you transfer assets to children, you're exposing those assets to the risks of the children, whether it be their marital situation, their creditors, their children applying for financial aid, a child predeceasing the parent and then not knowing where those assets are going to flow through to. And then you have the thing that is saddest, but I see quite frequently, is then children that forget that they are assisting the parent protecting the asset, and then all of a sudden thinking, no, this was intended for me. And then they are reluctant to use the asset back for the parent. So when you transfer assets outright, they're exposed to a whole host of issues, including taxes. You may lose a step up in basis for the taxes. It may then result in reporting the income to the child as opposed to the parent. So these trusts can be structured in a way where they're still taxable to the parent, but it's managed by the children. All of it involves giving up some form of control. So it has to be something that the parent is comfortable with. But trusts are a frequently used tool in the Medicaid planning or the asset preservation planning world.
Now, you said an irrevocable trust. Can you kind of explain the difference between that and, say, a living trust?
Sure. So a living trust is a trust that is created while someone is alive. And that trust could be either revocable, it could be irrevocable. So both of those are living trusts. The real key is, does the person who created the trust, the grantor, the settlor, whatever the name is in that particular case, do they have the right to manage the property, control it, take it back, rip it up, If they do, that's revocable, and they have all the power. But that only has limited abilities. For example, it doesn't insulate it from the government benefit world. It doesn't insulate it from creditors because it's essentially a see-through trust. If someone's trying to look at those assets, they're just going to say to the grantor, just revoke it. They're really yours. You can control it. But what that's usually done for is to avoid the probate process. Because probate is different in various states. In New Jersey, where I am, New Jersey is really not an issue. It's fast, it's cheap, it's simple, there's very limited court involvement. It is really a non-issue, and people spend more time and energy and money creating a trust and administering a trust and then dissolving a trust than they would just going through the probate process. But you compare that to states like Florida, California, New York to a lesser degree, but where there are states that are a little bit more complex for probate, and there's more cost, there's more court involvement, there's more public disclosure of assets, then there is a desire to avoid that process more often. And that's where a revocable living trust is really helpful. There are articles on this all over the place. And when people come to me and say, I think we want a living revocable trust to avoid probate, and they say, well, I read an article or I looked at it, I said, where was that article published?
Right.
Tell me the state it was published, and I'll tell you if it applies to you. There are other reasons to do revocable trust. Sometimes a good example is when there is a senior that may have diminished capacity or is maybe vulnerable and susceptible to influence from others. Doing a revocable living trust may provide a little bit of insulation and assistance, so you're putting somebody else in charge so that there is a seamless transition if and when that person's cognitive abilities really decline, and it provides a source of insulation if there is somebody putting pressure on that individual to give away assets or maybe change their plan. So that's another opportunity for a living trust. Sometimes if there is a will is a public document. So sometimes if you have things in a will that you don't want people knowing, a trust is a private document. So whether you're a celebrity or you're making provisions there that you really don't wish to disclose, or maybe you have an estranged family member, there are reasons to do revocable living trusts. Irrevocable trusts, people need to be aware they are giving up control, and that's often difficult for people to accept, and you need to have a motivation and a purpose for that. So government benefit planning for Medicaid is a defined purpose. People still have to realize they're giving up control to somebody else. They can still retain some decision-making. They can still reallocate who may get the assets when they pass away, but they're giving up control. Other examples of why irrevocable trusts are useful for estate tax planning in those appropriate circumstances where you need to get it out of your estate. It may need to be in an irrevocable fashion. And those would be examples when irrevocable trusts make sense.
Now, does a trust continue after your death?
It depends. That's the typical lawyer answer, because trusts do so many different things. So a trust could continue after death, or it could terminate upon death. It really depends on what the specific provisions of the trust are. It could say that this remains in trust for my lifetime, and generally one of these asset protection Medicaid trusts do just that. It says this remains in trust for my lifetime. Upon my death, it will be distributed to whomever. Usually it's a mirror image of what the will would otherwise say.
Right.
However, there are many circumstances where you want to have trust continue beyond the individual's death. And there are a whole number of reasons for that. It may be because there's a child with special needs and they're on government benefits and you don't want to leave assets to that child because it could disqualify them from government benefits. That's a good, a routine example. But the one that is now really the preeminent reason for some of these trusts is second marriages, multiple marriages. So something that has changed dramatically over the 30 plus years that I've been practicing is in 1992, when I started, probably the divorce rate and the rate of multiple marriages, second marriages, children from prior marriages was much lower than it is in 2024. This wasn't as on top of people's mind. Now it's routine. Now anybody you speak with is either in a multiple marriage, know somebody in a multiple marriage. It is very typical to have a step parent, a stepchild, estranged family members. So the landscape has changed. And in those cases, trusts are really extremely important. Because one of the things, and we talked about what is elder law. Well, elder law is a lot of different things, and one of it's probate litigation. I do a lot of litigation, a lot of estate administration, and this all kind of falls within that. So you want trusts potentially for a surviving spouse. Because if you have a situation where one spouse leaves everything to the surviving spouse, without any parameters, the survivor can change everything and do whatever he or she wants. Mm-hmm. So you have a second marriage situation. Husband has children from a prior marriage. Wife has children from a prior marriage. Maybe they have children from a common marriage. So it gets complicated. But if spouse number one leaves it to spouse number two with the hope and the thought that spouse number two is going to do, quote, the right thing that they agree to, you're going on a wing and a prayer. Because the day after that individual passes away, spouse number two could do whatever he or she wants. Forget children from spouse number one, leave it all to children from spouse number two, or do whatever he or she pleases. Or you're going to have now spouse number three when the new spouse marries someone else.
Right.
And then that's where there needs to be focus on planning. That's where these extended trusts are sometimes appropriate. Now, don't misunderstand me. These are not easy or pleasant conversations.
Yeah.
Because it's like having a conversation about a prenup. Because in most people's minds, this is going to be happily ever after, and we're not going to think of anything bad that happens. But as a litigator, I see everything bad that happens. When people say, don't worry, that's not our family, it is exactly their family.
Right.
So planning in that context, I cannot overemphasize that when you have these situations with an estranged family member, a multiple marriage situation, a disabled child, or the other thing that happens frequently is parents are worried about their children receiving money outright. Mm-hmm. Certainly if they're of an age of minority, if they're too young, you don't want those children receiving assets early. So maybe they have to wait till 25 or 30 or 35, and you need to put somebody in charge of those assets. So that's another example of a trust that would extend beyond death. Then you have situations where children are just not capable of managing or handling money at all. And those may have to be even more extensive trusts. Or the one we get all the time is, oh, I don't want any money going to my in-law. Yeah, it's fine that it goes to my child and it goes down the bloodline to my grandchildren, but no way I want my in-law getting that money. In which case, maybe a lifetime trust for the child is appropriate. So as you can see, there is so many different permeations of what's appropriate, and it's all fact specific.
So obviously, and I tell people this all the time, it's not cookie cutter. Everything's kind of specific for you. What are some of the common mistakes that you see people making when it comes to, I'm going to call it the elder law?
Okay. Well, I'll give you the number one. A couple of are just my favorites. So LegalZoom is my favorite company because that is an annuity for future work. People that do their own wills, bring it on. Those are just recipes, the fill in the blank wills.
Right.
Though we see that litigation all the time, or a cross out on a do-it-yourself form. I think that's self-explanatory.
Right.
But the one biggest mistake that I always highlight to people is beneficiary designations. Mm-hmm. So if there's one takeaway, without getting too detailed, there's something called probate assets and non-probate assets. So probate assets are assets that are controlled by your will. And for the sake of the discussion, let's pretend that you have a client that has done the best estate planning in the world. They got great advice. The documents are perfect. It creates trust for whoever they want to create trust for. Disabled child, non-disabled child, second spouse, doesn't matter. All the documents are perfect, and the will does everything it needs to do. What people don't understand is the will only controls probate assets, which is often a fraction of what people's total assets are.
Mm-hmm.
Non-probate assets are assets that pass outside of the will. So examples of those are joint assets, assets with beneficiary designation. So life insurance, annuities, retirement accounts, payable on death or transfer on death accounts. Those are all examples of non-probate assets. And usually when you look at somebody's asset list, a large portion of their assets fall into that category of non-probate because they have retirement accounts, they have life insurance, most of their assets are owned jointly. So if those assets are owned jointly, the asset automatically goes to the surviving joint owner.
Mm-hmm.
So your will may say, I leave everything in trust for my disabled child or my second spouse, and that's great. But if you name the child or the spouse as a beneficiary of a retirement account, that asset will automatically go to that designated beneficiary, and it may be completely inconsistent with the plan that they thought was established, the trust that was created. Now you're doing damage control. What if the money goes to a child and it disqualifies that child from government benefits? You got to fix that problem, which is much harder to do. What if it now goes outright to a spouse and the spouse then changes that beneficiary designation later? It defeats the entire plan. And there's multiple examples of that, but it all stems from the beneficiary designation. So when I talk to people about doing their planning, yeah, I always say it's not just about the assets, it's about the assets and the beneficiary designations. And I want you to tell me exactly how these things are titled. And before this plan is finished, we're going to make sure that they are either titled correctly or retitled, because you have to tie the whole plan together with a nice bow. And then if you have a trust in the will, you need to name the trust as the beneficiary on that account. Or sometimes you have to remove a joint ownership situation. And then you get into the details and arguments of, well, was it intended to go to that joint owner? Was that the intent and purpose? Or was that joint account one of convenience? The other person was only there to give check writing ability to help mom. Those are sibling disputes all the time,
Right.
Because you may have a will that says, I leave everything equally to my 3 children. And then you have the majority of the bank accounts in joint names with the daughter that lives closest.
Right.
Question is, do the joint accounts go to the daughter who lives closest? Or does it go as intended under the will? And the answer is, I have no idea. And that's where the litigation begins.
Right. Right. We've run in quite a few times with clients that have said that, oh yeah, I have trust set up. And we start looking at documents that as we're preparing their personal tax return, and I'm not seeing anything titled in the name of the trust, and start asking that question. So from your standpoint as the elder attorney, do you, when you create trust for people, do you push it back on them to make sure that they get everything transferred? Is that something that you do? Is that something that you just follow up with them to do? And then kind of what's your follow-up process after that? I mean, how often do you meet with them after everything's been created?
Well, there's no point creating a trust if the people aren't going to use the trust or fund the trust.
Agreed.
And that goes to something I said earlier is, you go through the time and effort to create a trust, and then is it really serving the function you want? The trust that avoids probate, that typical revocable living trust, you got to put all your assets in the trust.
Mm-hmm.
So if you don't put all your assets in the trust, you're still going to go through the probate process anyway, and it defeats the purpose of the trust. So certain things are easy. Obviously, if they have a house or property, you're going to want to retitle them by deed into the name of the trust. But then you have to remind people, you got to put your accounts in there. You got to put your other assets in there, your brokerage account. And you tell them, and sometimes they do it, sometimes they don't. And I'm like you, people come to me and they go, all right, I got this trust. And my question is, well, is what's in the trust? And their answer is, I'm not sure.
Yeah.
Or I have the opposite situation now where there is a trust on record with an institution, but no one has a copy of the trust.
Yeah.
So now the individual died, and the institution said, we need to have a certificate or somebody, proof of a trustee, but no one has a document. So we now have to go to court to get a trustee appointed on a trust that we don't know what it says. So who do you notice? Who are the interested parties? You have, hundreds of $1,000s stuck in an account that you can't get out of because you don't know who's supposed to get it. And how do you convince a judge that the right person's getting it? And who do you notice to make sure the judge accepts that the proper people have been identified that may have an interest in that money? So I'm of the belief that you try to keep things simple. So with trusts, the more complicated things get, the more things that could go wrong.
Right.
And you have to really then have the discussion. It's a two-way street. Professionals and lawyers, accountants can offer information and can provide assistance. For example, I make sure people change their beneficiary designations.
Right.
I will give them the written instruction how to do it. That being said, nowadays everything is done so much online.
Yeah.
It's not like they bring me a form anymore. We fill it out and have them sign it and return it. Now I have to go online and do that. So I give them the language to use, but whether they do or they don't do it, I don't know. The other thing in this electronic world is I've written an article on this, is because of that electronic type of world we live in, when someone fills out a beneficiary form, how do you know it's really that person filling it out?
Right.
Because there's no signature sometimes anymore. You don't know who's on the other side of the computer, and you don't know who's with the person on the other side of the computer. So when there's an unusual beneficiary designation and it's going to a particular person that may be of question to other individuals, maybe a caregiver, maybe a significant other, a friend, or whatever it is. Those are questions, and there's liability, I think, to the institutions.
Yeah.
What are the institutions doing to confirm the validity of those beneficiary designations? So yeah, there's some responsibility for the person creating the beneficiary designation, but I wonder about what the future liability is going to be for institutions that don't do their due diligence and maybe do a follow-up call and say, hey, we got your form. Did you sign it? Is this what you wanted to do? So there's something in a file that if a case goes to litigation, they've done some independent verification as opposed to just someone hitting buttons that you don't know who was doing it. So there's a lot of complexity, and I think it's going to get even more interesting because some states are doing electronic wills now. And New Jersey has legislation pending about electronic wills. And kind of like the LegalZoom, bring it on. Happy you're doing it, because there are going to be so many potential problems. Again, what are the protections? Who's doing it? Who's there? Is somebody with you? How do you prove it? So, with the more technology we get, it may make things easier to do, but it also may create more disputes and litigation.
Yeah. I have a client right now. You talk about the bank and trying to handle it. Well, right now, parent passed away, and they're trying to, because they're the executor, they're trying to move stuff around or whatever. In there with this particular account, it's a trust account, and the bank never got a copy of the trust when it was set up. So now the bank's scrambling, and they're like, well, we can't release the funds to anybody because we don't know.
All right. So who's responsible for fixing that mess?
Yeah, exactly. That's what they're going round and round right now, trying to figure out. So there's definitely some issues, with that. And I can see where you're talking about with the wills, because you're my elderly father, and I decide that, hey, I'm talking to you, hey, let's cut Johnny out of the will, and we redo it and then send it in. And who's witnessed it? Or have I done it on my own without you knowing?
Exactly. It just creates a whole nother dynamic. There are so many will contests now based on unusual circumstances. You have the extremes. Obviously, you have the deathbed wills
Right.
We're getting medical records. Is the person on morphine? Did they stop? I mean, those are the classic examples. But then you have the other examples is there is a fine line between influence and undue influence.
Right.
People can ask for advice, people can offer advice, but when do you cross the line of coercion and doing something the person ordinarily wouldn't do? And that's why I said earlier, it's like reality TV, because you can't make up all the fact patterns. They really come right out of a screenplay. And you see sometimes the worst of people, and it's sad. Dealing with the special needs trust, oftentimes you see the best of people. You're helping people. You're enhancing someone's life. But with these estate disputes, they're sometimes just so unfortunate because, with regular commercial disputes, it's about the money, but it's business people fighting over contracts and money. When you're dealing with estate disputes, you're dealing with emotion combined with money. And emotion is much more difficult to curtail and explain. And you say treat it as a business decision, and people are incapable of treating these disputes as a business decision because these emotional conflicts go back to childhood. The fact that, brother got, more from the parent or did less for the parent. I'm the one that took him to the doctor and you didn't. And it gets into the things that you're never going to fix in a lawsuit. And that's what makes them so difficult and so raw and so expensive because people never want to give up. They always feel that they're going to get the last word. And if they just get to tell the judge their story, then someone's going to say, you know what? You were right and they were wrong. And people don't appreciate the fact that that's not the way it works in real life.
Yeah, that's for sure. Richard, we've gone over a bunch of stuff. I mean, we could talk for hours about this because I'm sure you got a ton of good stories. What have I not asked you you wish I had?
Well, I think the one thing that if I had to pick the one to emphasize, I did it, and that's the beneficiary designations.
Yeah.
And I think it's about awareness. You need to take responsibility for. It's not an easy subject to think about. It doesn't matter whether it's long-term care planning, because no one thinks they're ever going to be in a nursing home or passing away, or sometimes being honest about your family situation, about having a difficult relationship with a child, or maybe any of those. These are not easy things to discuss. But, and people are often paralyzed about making a decision because they don't know how to make a decision or how to communicate the decision. But not making a decision is a decision because these estates are going to get handled or the assets are going to get dispersed or spent in a way that you may not intend, but that's the result of someone not having a conversation and making a decision. So I think it's really emphasizing the importance of having this top of mind, making it a priority to have a discussion, do planning, making sure you do your due diligence because there's so much misinformation out there.
Mm-hmm.
People can, come in with all of these crazy theories and said, I read that, but none of it's true. Or they mix up what's appropriate per state. Again, the probate versus non-probate, it applies to some, but not all. So I think just making sure that people are comfortable with this discussion and this topic and don't procrastinate with it because this is important at any age. Elder law, I know says elder law, but it incorporates everything. So someone that just has a baby needs a will to have a guardian appointed for a child or a trust for the child. It applies to every circumstance in every situation. So people say, I don't need it. I'm not a high net worth individual. It doesn't matter. This is for everybody in one form or another.
I totally agree. Richard, if people like what they hear and they want to reach out to you, how can they reach you?
Sure. Well, I'm the chair of the co-chair, or I'm the chair of the Elder Law Department at Mandelbaum Barrett. Our main offices are in Roseland, New Jersey, but I'm licensed in New Jersey, New York, and Colorado. We do work all over the country. And my email address, which is the easiest way to contact me, is rmiller@mblawfirm.com. mandelbaum.com. VMB stands for Mandelbaum Barrett. And I'm happy to give my direct line, which is also the best way to reach me directly, and that's 973-243-7916.
Great. Richard, I really appreciate your time and enjoyed our conversation today.
Same here, Gary. Again, thanks for having me.
Sure. Hey, this week my guest was Richard Miller, and he is a certified elder law attorney. Thank you, guys, and I'll see you next week.
49 faces looked to him in triumph. Over the last 12 months, they had each taken turns and promoted his business for a week at a time, driving over $987,342 in revenue. What if you had a network of 50 centers of influence who promoted your business every week for a year? Grab your copy of the #1 Amazon best-selling book, The Ultimate Guide to Growing Your Business with a Podcast, at 33% off the Amazon price by going to ultimatepodcastbook.com. Again, that website for 33% off the Amazon price is ultimatepodcastbook.com.